From WPTC News Channel 5, this is breaking news.
We are joining you live this morning as Corrections Officer Gene Palmer makes another court appearance. Good morning, I'm Vanessa Bashanian.
I'm David Schneider. ED is scheduled as a pre-trial conference officially for the man who's pleaded not guilty to multiple charges for his role in the escape from Dannemora. The judge just walked in as well. Let's listen in.
In the first degree, 2 counts of tampering with physical evidence, and 1 count of official misconduct. Mr. Palmer appears today with his attorney, William Dreyer, representing the people, his district attorney, Andrew Wyatt. The court clerk has been informed that rather than proceeding to trial, the defendant wishes to enter a plea today. I believe there is a negotiated disposition as to the number of counts he will be pleading to. In any event, I would ask District Attorney Wiley to place his understanding on the record.
Thank you, Your Honor. Good morning. Your Honor, after very extensive investigation that the Clinton County District Attorney's Office, in conjunction with the New York State Police, the Inspector General's Office of New York, and local, state, and federal law agencies, taking into consideration all of the information that our office has at hand, the people of the state of New York feel it's in the best interest to dispose of Mr. Palmer's matter. Today we've been ready to do that for some time, and just working out the specifics of the final disposition, which as the court's aware and Mr. Palmer and his counsel are aware, the people have agreed to in part, and in part are leaving sentencing to the court. In satisfaction of Superior Court information, the people are willing to dispose of this matter in the following manner: that the defendant would plead guilty to the reduced charge of the first count of promoting prison contraband in the first degree, to promoting prison contraband in the second degree, which is a Class A misdemeanor. The defendant would plead guilty to the second count of promoting prison contraband in the first degree, which is a Class D felony. The defendant would then plead guilty to the 5th count of the Superior Court information, official misconduct. Those 3 pleas would be in satisfaction of the 5-count Superior Court information, that the court would obtain a plea colloquy to the extent the court deems it appropriate from Mr. Palmer relative to those 3 counts, and it's my understanding that the court will also make reference to the allegations, at least in counts 3 and 4, with Mr. Palmer, to have him acknowledge that conduct, but he would not be required to enter a plea to those charges. And that is just in a matter of being able to dispose of this case today to move the matter along. It's my understanding in negotiating this case that the court deems a $5,000 fine in a manner which the court would impose upon the defendant in the amount of $5,000 to be appropriate. The people have no objection, of course, to that, as we agreed to that. Other terms and conditions of sentencing would be as follows: that the incarceration or supervision or community service supervision would be subject to the court's discretion. And of course, with the D felony, the maximum sentence that Mr. Palmer could receive is 2 1/3 to 7 years in state prison. But the court has the option of sentencing the defendant to a 1 year in the county jail, a full or a period of time in the county jail, a term of probation with jail, or just straight community service or a conditional discharge. The conditions of sentencing would be that the defendant would submit and provide a DNA sample and pay the DNA fee, that the defendant would be resigning from the New York State Department of Correctional and Community Supervision. And it's my understanding that the papers for that have been executed by Mr. Palmer. His counsel has those documents in their possession, and they will be filing those today with the appropriate agency. Relative to restitution, I would anticipate that restitution would be an issue that may be discussed following our court appearance today. But as the court is well aware, the parties to this action are well aware that Mr. Palmer cannot, based on the charges he is charged with, which I feel are the only charges that we can charge him with, that he cannot be held accountable by the state of New York for the restitution amount, which on the prior 2 cases involving Sweat and involving Mitchell was set at a monetary amount of $79,000 for the repair of the facility. And Mr. Palmer would not and cannot be held liable for that indirectly or directly. I believe that the only other issue, Your Honor, is that by entering his plea today to satisfy Superior Court Information 144S151081, that Mr. Palmer would be waiving his right to trial, waiving his appellate rights, and post-conviction remedies. Other than that, I believe that encompasses the recommended disposition by the people. Of course, the actual incarceration aspect is subject to the court's discretion, and we're ready to proceed with a plea and if so, sentencing today. Thank you.
Thank you. Mr. Dreyer.
That accurately sets forth the agreement that we have, Your Honor. We concur.
That being the case, I would ask Mr. Palmer to stand and be sworn in.
Raise your right hand. Do you solemnly swear the testimony you shall give in this issue should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Please state your name for the record.
Gene Palmer.
Mr. Palmer, if I ask you a question that you don't understand, please agree with me that you will stop the proceeding, and I will allow you to consult with Mr. Dreyer. Do you so agree?
Yes, sir.
Do you understand that you have an absolute right to remain silent in the face of the charges lodged against you, and that by entering the plea of guilty, you give up that right and incriminate yourself?
Yes, Your Honor.
Have you had enough time to discuss this matter with Mr. Dreyer to make an intelligent decision?
Yes, Your Honor.
And are you satisfied with his representation?
Yes, Your Honor.
Do you understand that rather than accept any plea offer, you have the right to proceed to trial, either before the court sitting alone or with the jury?
Yes, Your Honor.
Do you understand that if you decided to go to trial rather than plead guilty, it would be the people who would have the burden of proving you guilty beyond a reasonable doubt in order to secure a conviction?
Yes, Your Honor.
Do you understand that if you went to trial, that you would have the right to take the witness stand if you wished, call witnesses in your own behalf if you wished, present evidence if you so wish, and through your attorney cross-examine any witnesses called against you by the people?
Yes, Your Honor.
Mr. Palmer, do you realize that by entering the plea of guilty, you give up these trial rights that I just mentioned?
Yes, Your Honor.
Are you entering this plea of guilty freely and voluntarily?
Yes, Your Honor.
Are you pleading guilty because you are in fact guilty?
Yes, Your Honor.
Do you understand that you would be pleading to 1 felony and 2 misdemeanors?
Yes, Your Honor.
Do you understand that the maximum sentence I can impose on the felony is an indeterminate period of incarceration, having a minimum of 2 1/3 years and a maximum of 7?
Yes, Your Honor.
Knowing all this, do you wish to proceed?
Yes, Your Honor.
The people have consented to a reduction of count 1 from promoting prison contraband in the first degree to promoting prison contraband in the second degree. Do you admit that on or about May 30th, 2015, you knowingly and unlawfully introduced contraband into detention?
Yes, Your Honor.
How do you plead to the misdemeanor of promoting prison contraband in the second degree?
Guilty.
Turning to count 2, the felony, do you admit that between November 2014 through June 2016, 6, 2015, you knowingly and unlawfully introduced dangerous contraband into a detention facility.
Yes, Your Honor.
How do you plead to the felony of promoting prison contraband in the first degree as charged in the second count?
Guilty.
Turning to count 5, the misdemeanor of official misconduct, do you admit that on or about November 2014, you, with intent to obtain a benefit, committed an act relating to your office, but constituting an unauthorized exercise of your official functions, knowing that such act was unauthorized?
Yes, Your Honor.
How do you plead to the misdemeanor of official misconduct as charged in count 5?
Guilty.
I accept your plea as being made knowingly and voluntarily. Previously, the court had ordered a pre-plea report to be prepared by the Clinton County Probation Department. Therefore, it is not necessary to order a pre-sentence report. We can simply convert this plea to a pre-sentence report. In fact, I don't believe that there's any objection and that actually this is urged upon you by both D.A. Wiley and Mr. Trotter. Correct?
That's correct, Your Honor.
We will now proceed with sentencing. And District Attorney Wiley, do you wish to say anything?
Nothing, Your Honor, other than what I've previously stated before, with the exception that I anticipate during this aspect of your dealing with the sentencing, you will address the allegations, at least in the third and fourth counts, correct?
I shall.
Relative to the paintings, I think.
shall.
Your Honor, I think that the fine amount that the people, the defendant and his counsel in the court have discussed being $5,000 is a reasonable and just fine to impose upon the defendant. Relative to incarceration, Your Honor, I'll be brief. I think that the conduct that Mr. Palmer had performed, not only post June 6th, 2015, when he destroyed the paintings that he received from Matt Andrew Sweat while they were incarcerated at the facility, but his conduct that led up to June 6th, although not directly related to the escape, certainly allowed the opportunity for that escape to occur, providing Sweat and Matt with instruments or tools to manipulate their cells, to have access to the catwalk area behind the cells, certainly allow them at least access to their eventually their escape route. And then the total, I mean, in my opinion, utterly disregard for the safety of not only other inmates but other prison guards that Mr. Palmer worked with on an ongoing basis leading up to June 6, 2015. With that being said, Your Honor, I think that in reviewing the plea investigation report conducted by the probation department, I think they did a very thorough job, as they're required to do, in outlining the allegations and outlining the background and history of Mr. Palmer. Mr. Palmer has no prior criminal history, with the exception of some limited allegations of and admissions from him of marijuana use. I don't believe that there is anything of a outstanding, long-natured history that would require probation supervision. That I think, in this regard, that Mr. Palmer needs to be held accountable for his actions, with his involvement with inmates Sweat and Matt and his supervision duties that he was provided at the facility. And so, on that being said, I think he needs to be incarcerated. I think that the court should impose a period of incarceration, Your Honor, whether the court deems that to be a state prison sentence or let's say a 1-year term in the county jail to be appropriate in this matter, that imposes a sanction on Mr. Palmer that holds him responsible. And as I said, from basically from day one in this matter, I would leave that portion of sentencing to the court, because I think it's, in this case, it is your responsibility for that. And so I will end on that. Thank you.
Mr. Dreyer, do you wish to address the court question?
Very briefly, Your Honor. First of all, we concur with Mr. Wiley that the pre-sentence investigation is very thorough, and we have no objections to it, nor do we have any recommended additions. The court, having read the report and also some submissions that we've made to the court, I think knows most of what I'm going to say, but very briefly, Mr. Palmer began his career as a corrections officer in 1987 and worked for a full 28 years with an unblemished record, and in fact, from year to year with accolades from superiors and even with awards being given to him over that period of time. Until, of course, June of 2015, when he was suspended for the conduct which is the subject of this case. The court is also aware, I think, from our submissions that we have spoken to scores of Mr. Palmer's supervisors, fellow employees, fellow corrections officers, and in fact, we've received scores of calls from former inmates who read about Mr. Palmer's difficulties and saw fit to call us to make comments in support of Mr. Palmer. Uniformly, the officers that we spoke to and the corrections officers and the supervisors spoke about Mr. Palmer's loyalty to his position, spoke about his loyalty to his fellow officers, and spoke about how hardworking he was, one of the most hardworking officers at the prison, and also noted that over a period of years it was Mr. Palmer who, because of the unique relationship, which he is now, of course, being held accountable for, but because of his unique relationship, helped to prevent violence, fights, riots, and other planned attacks on both women in the prison and also other inmates, and in some cases, corrections officers. And that is because he had established a trusted relationship with several inmates, including, ironically, Matt and Sweat. It was because of that particular relationship that he had in the prison that he, of course, during a certain period of time, had agreed to give favors or benefits to these prisoners in exchange for the information that he received, to the knowledge, for the most part, of many other corrections officers and supervisors in the prison. This was the reality of the prison, and this was what he chose to do with the acceptance of other people at the prison. He acknowledges that he relaxed the rules, as Mr. Wiley has said, and committed wrongdoing. And in the context of what has happened since, he's acknowledged, not only to the state police, but to the court, that some of the things that he did which led to count 1, 2, and 5 were violations of the law. No question about it. At the time and in the context of what he thought he was accomplishing, he thought it was in the best interests of all parties. The inmates who called us, some noted that in one case, an inmate who had been exonerated after spending years at Dannemora had noted that Mr. Palmer was a person who treated him humanely. Another person called who said that his father had been ill during his time at Dannemora, and Mr. Palmer was known in his family as somebody who treated his father with respect and humanity. I think that the most important thing that's resulted up until today is that Mr. Palmer has acknowledged his responsibility, has accepted responsibility. On the day after the prison break, or a few days after the prison break, Mr. Palmer was asked to be interviewed by the state police. And there wasn't one issue or question ever raised. He went, he talked to them, he thought he was assisting them in any way that he could. It is unrefuted, I believe, at this point. It is unrefuted that all of the people who investigated this case, including the state police and everyone up to the district attorney's office, and certainly his defense attorneys, that Mr. Palmer had no idea that he was knowingly aiding anybody to escape. The last thing he ever thought of was that there would be an escape at Dannemora. It was an unprecedented circumstance. He never thought about it. So when he found out about it, he was just as surprised as everybody else. Suffice to say that he has accepted responsibility, he's remorseful, and he now asks the court to sentence him in accordance with his background and the facts and circumstances of this case.
Thank you. Mr. Palmer, before I proceed with sentencing, you have the opportunity to address the court. Is there anything you wish to say?
No, Your Honor.
Very well. This court is not unmindful that this case has received a great deal of publicity, both nationally and locally. Given the widespread and legitimate interest that our community has in these proceedings, I want to be sure that everyone has a good understanding of just what is taking place here today. Therefore, while my comments are particularly directed at Officer Palmer, I want to take the time to carefully go over the charges filed before the court and the charges to which Mr. Palmer has pled. They are not the same. Mr. Palmer was charged with 2 counts of promoting prison contraband in the first degree. The definition of promoting prison contraband in the first degree requires the people to prove that a defendant knowingly and unlawfully introduced dangerous contraband into a detention facility. Dangerous contraband is defined as contraband which is capable of such use as may endanger the safety or security of a detention facility or any person therein. Count 1 references the introduction into the facility of hamburger meat in which was concealed a hacksaw blade. Count 2 references the introduction into the facility of a screwdriver and a pair of needle-nose pliers. Relative to Count 1, the operative word in the definition as it relates to the facts of this case is knowingly. Officer Palmer vigorously and adamantly denies that he in any way knew that there was anything concealed inside the hamburger meat that was given to him by employee Joyce Mitchell, and states in his pre-sentence report interview that it was commonplace for inmates to cook inside their cells. It is crucial for anyone wishing to understand what is happening in this disposition to realize that indeed Count 1, by agreement of both the people and the defendant, has been reduced to promoting prison contraband in the second degree. Promoting prison contraband in the second degree simply prescribes the introduction of any contraband into a detention facility and is a misdemeanor. Officer Palmer, therefore, is admitting to knowingly introducing hamburger meat into the facility and nothing more. This is a very important distinction, since the court would be proceeding with a significantly longer sentence if Mr. Palmer had admitted to knowingly introducing into Clinton Correctional Facility a hacksaw blade. Turning to Count 2, the defendant is pleading to the original felony charge and therefore is admitting to introducing into the facility a screwdriver and needle-nose pliers, objects which the court believes could clearly be viewed as dangerous contraband because of their capability, under certain circumstances, of endangering the safety of the facility. Lastly, Officer Palmer is pleading to the misdemeanor of official misconduct. The crime of official misconduct occurs when an individual uses his position to perform an unauthorized function in return for receiving a benefit. As it relates to the facts here, Officer Palmer received paintings from inmate Matt and in return purchased paint and paint supplies for him, provided him with the aforementioned hamburger meat, moved inmate cells and provided inmates who had access to the catwalk behind his cell so that he could alter an electrical box, which would enhance his ability to cook meals. He also allowed inmate Matt to hide the paint supplies he had purchased for him in the catwalk so they would not be discovered during cell inspections. The pleas to these crimes are in satisfaction of 2 felony counts of tampering with physical evidence, wherein it's charged that in the aftermath of the escape, Officer Palmer first buried paintings received from Matt and then later dug them up and burned them. While he is not required to plead to these offenses, he does not deny committing the underlying acts that were alleged. So, in summary, Officer Palmer was charged with a total of 4 counts, 4 felonies, and 1 misdemeanor, and is pleading guilty to 1 felony and 2 misdemeanors. The most serious count is, of course, count 2, the felony count involving the introduction into the facility of the screwdriver and needle nose pliers. This charge is a D felony and carries with it a maximum sentence of 2 1/3 to 7 years in prison. There is no negotiated sentence in this case, so sentencing is left totally in the court's discretion. What is an appropriate sentence? The first topic addressed in any pre-sentence report is the criminal history of a defendant. As a practical observation, I would note that the great majority of defendants appearing before me have some criminal history. Officer Palmer does not. He has been employed as a New York State Corrections Officer for 28 years. And from what I can tell, without incident, or without ever receiving any reprimand or employee sanction. The pre-sentence report indicates that he became a highly lauded employee. He had received an award as the Employee of the Month. Of particular interest to the court is Officer Palmer's assertion that he worked closely with the administration because he had a good knowledge of the goings-on within the facility. An argument has been made by Officer Palmer that his actions were merely reflective of a culture that existed at Clinton Correctional Facility, wherein sex, drugs, and violence in the inmate population were always present. This culture led he and other officers to seek to maintain order and safety by doing favors for inmates in exchange for the valuable commodity of information. Such information could be priceless in keeping corrections officers and civilian employees, as well as inmates, safe. He contends that he was not the only corrections officer who provided items to inmates, and he takes issue with the administration for being ignorant of those issues and the danger that the corrections officers take. That the culture that Officer Palmer describes exists at Clinton Correctional Facility, I do not doubt. That the administration did not know about how certain corrections officers were dealing with this culture, I find somewhat incredible. However, even if the administration turned a blind eye to what was going on in the facility between inmates and corrections officers, and thus tacitly approved the conduct, each individual who engages in these actions subjects himself to the consequences when these actions cross the line into criminal behavior. Likewise, the fact that other officers were also engaged in this conduct does not absolve Officer Palmer's criminal culpability. The points that Officer Palmer and his attorney raise are valid as mitigating factors in the sentence, but they are not criminal defenses. In determining what I believe to be a fair sentence, I have taken into consideration these points. turning to the various sentencing options that are available to me, I first have ruled out any sentence of incarceration in the Department of Corrections. While sending any corrections officer into a prison population as an inmate would create a monumental practical challenge to the department, I believe that this scenario has arisen before and that the department could effectively deal with it. My reasons for objecting this option have been previously stated, namely the lack of any criminal history by Officer Palmer, his 28 years of unblemished service as an officer, and the previously mitigating circumstances. On the other end of the spectrum, I have also rejected any sentence of probation, be it straight probation or so-called split sentence, wherein the defendant receiving a probation term can also receive up to 6 months incarceration. The reason for rejecting probation is that Officer Palmer simply does not need the rehabilitative measures employed by a probation department. As stated previously, he has been a law-abiding citizen throughout his life, and I have no doubt that this unfortunate matter will be all the more reason why he will continue to be law-abiding. I also have noted that Officer Palmer will now resign from the Department of Corrections. Furthermore, I have taken into consideration that he has cooperated with the investigators from the Inspector General's office and has answered all questions to their satisfaction. In the end, however, Officer Palmer, I do believe that some incarceration punishment is clearly warranted here. While your actions may have been taken with the best of intentions, the introduction of the screwdriver and pliers into the facility have the potential of actually making the facility less safe, not more. The purchasing of paint supplies for inmate Matt and allowing inmate Sweat to become familiar with the catwalk area behind the cells were egregious violations of your duties. Furthermore, while you have not been required to plead to the tampering of evidence charges, you have admitted to burying and then destroying criminal evidence. Taking all of the above matters into consideration, I have determined to sentence you as follows. On count 1, the misdemeanor of promoting prison contraband in the second degree, I impose a fine of $1,000. On count 2, the felony of promoting prison contraband in the first degree, I impose a fine of $3,000 and a definite jail sentence of 6 months. On count 3, the misdemeanor of official misconduct, I impose a fine of $5,000. The court surcharge, DNA fee, and crime fee totaling $375 are also imposed. In summary, Officer Palmer has been sentenced to 6 months incarceration and fines and surcharges totaling $5,375.
Your Honor?
Yes.
Just before you go further, could you just clarify, I think on the record, and I may be wrong, for the third count, you may have mistakenly said $5,000.
No, it's $1,000. I'm sorry.
Thank you.
Thank you for correcting. Please sign the DNA form, and with that said, I'm going to remand you to the custody of the sheriff. That having been accomplished, I believe this concludes the matter.
Your Honor, thank you very much.
Thank you, Judge Ryan.
What you just heard was Gene Palmer being sentenced. Again, he just agreed to a plea deal with some lessened charges, and he was just sentenced to 6 months in jail with an addition of thousands of dollars in fines. The reduced charges was 1 count of promoting prison contraband in the first degree. That's a misdemeanor. The second was promoting prison contraband in the first degree, which was a felony. And then the last is another misdemeanor, the official misconduct.
So Gene Palmer, essentially in this plea deal, has admitted that he did bring hamburger meat into the inmates, although did not realize that he was bringing hacksaw blades to them. Did bring some tools to them, admits that he did let them have access to the catwalks behind their cells in order to access an electrical box to cook meat. The judge points out that this was reflective of the culture there. In other words, exchanging favors for inmates to get information about what was going on to help keep the inmates safe. The judge took all of that into consideration as well as an exemplary record, he said.
That's right. And coming up at 5 on WPTZ, we'll have a full report of the sentencing and the final chapter in the case of the Gene Palmer part of the escape from Dannemora. Again, that's going to be at 5 tonight. Again, thank you so much for joining us. Have a great afternoon.